Welcome to Switch Moments, brought to you by Brave Switch and Young Wealth Management and Estate Planning Company Limited. Today we'll be talking about whether or not a blind person can make a will. Interestingly, when you ask a couple of people, the response you would get is, I don't know. But today we'll be addressing this issue because we feel it's very important. Now, straight to the point. Can a blind person make a will? The answer is simple. Yes. Ordinarily, the law would not deprive an individual from passing down his properties to his beneficiaries, his heirs, his children, his spouse, or her spouse. So the law makes it possible for the blind person to make a will. However, there are certain other conditions that will must fulfill, or the testator must fulfill. For the purpose of clarity, a testator is someone who makes a will. So in this instance, the blind person is the testator that we're talking about here. So the law makes it possible for the blind person to make his will, but gives certain conditions and requirements that he must fulfill before that will can be valid. Now let's go straight to the point. Yes, a blind person can make a will, but what does he have to do so that his will be valid? The law makes it a requirement that that will must have been read over to him, and he must actually express the fact that he understands the content of the will absolutely. Now, there's a particular word here that you will find, which is over. So, which means that you don't have to read the will once and feel, oh, like I've done that obligation is fulfilled. But you have to read it over and over again until the content of the will is perfectly understood. So, after that, he can now append his signature to the will. Another very important point to note is that the court under normal circumstances would ensure that the evidence to show that the will was read to the blind person over and over again is provided, or is before the court, before the court can actually grant probate of that will to the administrators of the estate of the deceased person. So let me make it clearer. Once a blind person makes a will and he passes eventually, the beneficiaries or the administrators of the estate of that blind person would definitely approach the court to obtain probate of that will. Before the court will grant probate of the will, in order to give them the powers to be able to distribute the estate, the court wants to be sure that at the time of signing the will, that will was read over to that blind person before he executed his will. Executed, I mean before he signed the will. So what would the court be looking out for? How would the court be sure that that will was read over to the blind person? Because at this time, the blind person would not, the deceased person who was blind would not be before the court to tell the court that, yes, this will was read over to me. So what the court does is that the law makes it mandatory that an attestation form, which is called a blind person's jurat, under the law is called a jurat. That document is signed by the person who read the will, the content of the will, over to the blind testator at the time he was supposed to sign the will. So once that document is completed, it is attached to the will before lodgement of the will at the probate registry. So at the time when the administrators of the estate of the deceased person will be approaching the court to obtain probate of the will, the court wants to see that attestation form, which is called the jurat, to show, yes, that this will was read over to the blind person before he affixed his signature to the will. Another very interesting part that we would like to talk about regarding blind persons and estate planning is that a blind person cannot attest a will. A blind person cannot attest a will. The reason is simple: because he is blind. That disability makes him incapable of attesting a will, because the essence of attesting a will is that you are witnessing the signing of the will by the testator. So what I'm saying in essence is that when I am making a will, some persons must be present to see me sign the will. What we are saying here now is that a blind person cannot be one of those persons who would be there to say they want to witness the signing of the will, simply because they are blind and they cannot see. So how then would they be able to tell that this was signed by the testator? By virtue of this, they cannot attest to a will. I hope you have gained one or two things today, and believe that we're coming back again with other insightful videos that would educate you about estate planning. Thank you.